Okay, there we go. All right, so for the folks that are on, we are just about at 12 o'clock now. I do see from the counter that there are people still signing in. So we will go ahead and give a minute or so to make sure that everybody who's trying to get in makes it in before we start the material. Still going up every time I check this number, so we'll just give it a bit for whoever needs to get in. I don't want to start without people who are trying to log on. All right. For folks that are waiting, apologies. The number is still not steady, so people are still signing on.
All right, I think we're a little bit stabilized there on the number, Gary.
Yeah, I just got the same number 3 times. So, okay, here we go. Thanks everyone for your patience, and more importantly, thank you for attending. I always say this, everybody always says this. It sounds sort of cliche or something, but we really do appreciate when people join us for these programs. If you weren't taking the time to be with us, then we wouldn't be able to do it. And we actually do like to do these things. And hopefully folks find it helpful. So we do appreciate everyone's time today. As the title slide suggests, this is exterior modifications, the need for board approval, and enforcement against unauthorized changes. My name is Gary Daddario. For those who don't know me, I'm one of the partners here at MEEB. I am one of the fellows of CAI's College of Community Association Lawyers. With us today is also Justin Magsarili. Justin is one of the attorneys here at MEEB. And Justin and I were speaking recently about the fact that we have both seen an uptick in the number of cases involving these issues. And that's why we thought it was a good idea for a program. We've both been seeing associations with, some type of problem under this sort of subject matter, under this umbrella lately. And so we thought it would be a good idea to try to get some information out there for associations. We can hit the next slide, Justin.
Hold on.
Okay, so I am choosing to start with this slide. I've used it before. It remains one of my favorites. It's applicable to almost every topic that we might ever speak of. But this language in quotes is directly from a judge who decided a case. As you can see in the citation below, the case was originally decided in Florida, and then the Florida judge was quoted by a judge in the Massachusetts Appeals Court because in the Massachusetts Appeals Court, they felt like the Florida judge really did a good job of stating the case. And honestly, so do I. I think this is one of my favorite quotes. It's something that almost everyone needs to hear, regardless of their place in the condominium world. Vendors, property managers, board members, every unit owner, everybody could serve to read this. Everybody should be aware of this. I'm just going to go ahead and be painful about it and read it out loud. Central to the concept of condominium ownership is the principle that each owner, in exchange for the benefits of association with other owners, must give up a certain degree of freedom of choice, which he might otherwise enjoy in separate privately owned property. And of course, it's the second half of this that trips up most unit owners. There are so many cases, enforcement cases, where the first communication I receive from an owner, whether it's a letter, an email, a phone call, they're all letting me know that they're not a tenant, that they bought the unit, that they own it, it is theirs, they pay their mortgage, and they're not interested in me telling them what they can and can't do. And at that point, we're off to a bad start already, because it lets me know that this unit owner, throughout their whole buying process, never actually learned what they were purchasing, because they don't understand sort of the scheme within which they're operating as a condominium unit owner. But eventually we get past that one way or another. Sometimes we can do it short of court, other times we end up in court. But generally speaking, most associations know, most boards, most property managers are well aware that the condominium documents as they are written are generally quite enforceable. The courts are pretty open to the notion that everyone has agreed to live by the language that's in the condominium documents, and therefore everybody should be living by that language. Hit the next slide, Justin. So we've divided the program today into about thirds, discussing sort of the subtopics relative to this issue. And the first section is, what do the governing documents say? As always, or almost always, when it comes to condominiums and associations and the issues and problems that arise, the association's own governing documents are an excellent place to start in just about every scenario, because almost all the time they are going to provide the answer to the question, or at least the starting point for the answer to the question. We can hit the next slide. So I've given some examples of types of language that I've seen and how it rates. I call this one okay. We're used to saying good, better, best, and I deleted good. I couldn't go so far as to say this was good, and I went with okay. There are those documents that simply state that any exterior modifications require board approval. That's nice, but it's lacking in the sense that it doesn't go far enough. It doesn't say how to get board approval. It doesn't say when to get board approval. And it really doesn't offer any sort of restrictions or qualifications for anybody to think about. And so while I suppose it's better than nothing, this one sentence, when that's all that I see in a set of condo docs, I don't feel like it does quite enough. And so this would be a bare bones. If people look at their docs and find that this is what language they have, you may want to consider an amendment to get something nicer in place. Go to the next one. So here's better. This is something else. Another expression of this same subject matter that we tend to see in documents. Any exterior modifications require prior written approval of the board. Why is this better? Well, for one thing, it gives us a when. By saying that the modifications require prior approval, we now know that the unit owner needs to have the approval before they do anything. And that's important for obvious reasons. It also tells us what type of approval there needs to be written approval of the board. And so there's no mistaking it. And so the reason why this language is better is because when this language is in a set of documents, we have an easier time sort of categorizing a situation. In other words, if the board thinks that someone's in violation, we have an easier time making a determination of that, because where written approval was required from the board, the unit owner either has it or they don't. And they can either show it or they can't. It's a lot more objective. And again, because they need that approval prior, they shouldn't be doing any work unless and until they have that approval to show. And so even though it's not much different, the language here that I've labeled as better does provide some important steps forward in terms of being able to address a situation and to do so in a more objective and fair manner at an association. We can go to the next one. I've labeled this best. This is ideal. I don't know that I've ever seen exactly this out there, but I've seen pretty close variations of it. Here it says any exterior modifications require prior written approval of the board. That's where we were before. It goes on to say owners will be required to provide contractor info, licensing and permits if applicable, proof of insurance, and documentation of the proposed scope of work. Finally, it also says easement or limited common area agreements may be required depending on the location of the work. Why is this the best? It's the best because it touches on all of the important points that need to be considered in the context of this issue. If a unit owner is paying attention to the docs and they're being a good unit owner and they're looking to comply with the provisions of the docs, then they now know they're going to request written approval from the board. They're going to do it prior to when their work starts. They're also on notice that there's other information they need to provide. The contractor info, the licensing, the permits, the proof of insurance. I'm not telling anybody anything they don't already know when I say that these things are critically important. Because if a contractor shows up at a building, even if they're doing work, on a portion of the exterior that, depending on the association and how the boundaries are described, even if they're doing work outside in an area that is somehow part of the unit, owned by the unit owner, or if it's a limited common area, it's an area that's reserved for this particular unit owner's use. Even under those circumstances, if a contractor comes in and does a bad job, if they don't know what they're doing, they make mistakes, they perform in some negligent way, the damage may affect more than just that unit owner. It could affect a part of the building that's common area, depending again on how the property is physically situated. It may have a negative impact on other unit owners. And so it's always important, regardless of where someone's working, for an association to be able to know that a contractor is a proper contractor, who has a license if they need one, who has a permit if they need one for this job, who's insured. If something goes wrong, there's nothing like insurance to at least create the possibility that there's going to be some funds around to be able to work out the problem and fix the problem. Finally, documentation of the proposed scope of work. That's important because if the board is being asked to approve something, they really need to understand what it is that they're approving or not. Otherwise, it's sort of impossible for them to make an informed decision, and there could be miscommunications that result in serious problems. And not all projects are created equal. Sometimes when someone wants to put a patio in the limited common area outside their unit, that's all it is. Sometimes when someone wants to put a deck on the limited common area during their unit, that's all it is. Other times, depending on the unit owner, that's sort of the starting point. And then the next thing you know, the walls go up and there's windows and there's a roof on it and there's all kinds of things going on. And now there's more or less an addition to the unit. Well, if that's what it's going to be, the board needs to know that up front, because the board needs to be basing their decision of whether they approve or deny the project on an understanding of what the project actually is. And of course, there are problems that flow from these situations when something different than what the board thought gets built. Then the other questions and problems flow from that. For instance, if a unit owner asks to build a deck and what they build is a deck with a 3-season enclosure on it, and then the roof leaks, we've seen it countless times. A unit owner might say, well, the roof is leaking, association, you need to do something about it because I know it's you guys that take care of the roofing around here. Well, maybe not. When unit owners ask to make exterior modifications, we typically advise boards to approve it on a set of terms that includes the fact that if a unit owner is adding something that wasn't there before, that they accept responsibility for taking care of it. Because otherwise it can become unfair. If the other owners are, through their common expense assessments that they pay into the association, if they're paying to fix someone's quote unquote extra roof because it's something they've added, That's not really fair to those other owners. So all of these things need to be considered, and the only way they can be is if the board has enough information about what is going on, what is actually being proposed. The easement or limited common area agreements, depending on, again, where the work is happening and what the status of that area is. Maybe a unit owner is putting something on common area, but maybe it's a temporary item. Maybe it's a necessary relocation of an air conditioner condenser, and it's just going to sit on one of these little plastic pads or something. And we're not really talking about a structure in the normal sense. We're not talking about something that can't be removed. Then even if it's common area, the board might find it reasonable to grant them an easement. But again, you want to do so with appropriate conditions where the unit owner is going to be responsible for this item going forward, so it's not going to cost the association. Even if it's a limited common area and the unit owner is entitled to the exclusive use of the space in question, it still makes sense for the board to enter into an agreement if they approve a project, because again, you want to provide for it being done right. You want to provide for it being maintained by the unit owner. And then when it comes to these agreements, we sometimes we will consistently think ahead and include appropriate terms for things that nobody wants to think about at the outset, which is, what about the termination of this? What if the unit owner decides one day that they don't want this thing anymore, whatever it is that they added? And so the agreements are where the association can say, by the way, if you ever get rid of this thing that we're allowing you to put there, you are responsible for putting the whole area back to the proper condition that it used to be in before we went through this exercise. And so, this is the best language because it covers all the bases. It lets a unit owner know what's going to be expected of them, and it gives the association the ability, with the unit owner having notice already, to sort of go through all of these elements, check all the boxes, and make sure the association is properly protected. Next slide, Justin. So when it comes to the condo docs or the association documents, what I find unacceptable, this is my own personal opinion and label here, but any language that does not require approval for the exterior modifications or a lack of language on the subject. It doesn't surprise me anymore. It's been long enough for me, and I've dealt with enough associations that it doesn't surprise me anymore when I find that for whatever reason, subject matter that a client is asking about is somehow not addressed in the docs. This is one that really should be there, and it really needs to have appropriate language. I've listed the fix here. It's easy enough. It's an amendment to the governing documents to insert appropriate language. Now, some might say, well, I don't think that's necessarily easy because amendments to the docs require a community vote. We can never get anything past our community. That gets to be a sort of what I call, for lack of a better term, a sales issue. How do you pitch the amendment to the ownership? And one thing a board can do if they need to pitch an amendment in this area is sell it to people by saying, this will help you if you ever decide that you want to do something that you need approval. This will provide a process and a way for us to do it in a fair manner. You can also give people the sort of flip side and let the unit owners know that this amendment, if it passes, will protect all of us from, for example, your next door neighbor doing something outrageous that you then get stuck living next to. So sometimes it's a matter of how it's pitched to the community. And, nowadays, as the law has been changing over the years, there are more avenues to get more participation easier. For example, associations can have electronic meetings now. In New Hampshire, there's a specific statutory provision for voting without a meeting. So there are options now. That's not what this seminar is about. But there are ways available, in the modern age, we'll call it, for associations to be able to structure things where if you need a community vote, you have a better chance of getting it because you can make it easier for people. Next slide. All right, so this brings us into the second part of today's presentation. This is going to be how should the board decide, and this is sort of what the board needs to think about and what they need to do when they are provided with a request for approval. And this is something Justin's going to speak to.
One thing I just want to note is that, that kind of example language that we were talking about, you won't necessarily see that language exactly the same way in your documents. It's going to vary to a certain degree. And in a lot of cases, it'll appear as sort of part of a like architectural integrity provision in the documents. So that's just another thing to kind of help you locate that kind of language when you're reviewing your documents to try and figure out what it is that you have existing. When the board is making the decisions on these kinds of requests, the standard that you have to follow for approval is going to be provided in your governing documents. So that the documents basically will tell you what is the threshold voting level for board decisions. So in Massachusetts, typically that's going to be contained in a declaration of trust. In New Hampshire, that's going to be in the bylaws that are typically attached to and made a part of the declaration of condominium. This goes to just sort of a core tenet of administering a condominium, which is just always check your docs first. I mean, that's your primary source of governance and essentially is your operating Bible. So typically, the most common standard that you're going to see for board decisions is a majority of board members at a meeting with quorum. We have seen documents that require unanimous decisions, but that's a very, very small minority of associations. And then there are others, again, less common, that require just a majority of board members. There are a couple of sort of exceptions that documents will build into. They may allow for a typical standard of a majority of board members at a meeting with quorum, and then a provision for a vote, a written vote, as long as it's unanimous. So it's important to note that individual board members are never allowed to act unilaterally. And you have to take care not to make representations to unit owners about what the board is going to do if you are speaking to them individually, without having run things by the rest of the board and having some kind of formal official decision. So as noted here on the slide, that includes discussions. Sometimes it's easy to be in a conversation with a unit owner who is speaking to you individually and discussing what it is that they're thinking about doing, and to kind of say, oh, yeah, that's not going to be an issue, or I anticipate that the board is going to approve that. You want to try and avoid those kinds of representations because you're speaking to them on an individual basis, and you can't really guarantee that that's what the outcome is going to be once it gets to the rest of the board stage.
Verbal discussions, I'll just throw in general, are not what you want in this area. Experience has shown that unit owners will tend to remember a discussion exactly the way they wished that it happened. And so you really have to be careful, because if that's what you're doing is having a discussion, then unlike a communication that's written where the words are captured, you run the risk that down the road, the unit owner is going to describe the discussion in a different way that you would have. And so erring on the side of caution means taking your actions in writing in this area as well.
Yeah, and it's also very important to try and kind of maintain a unified front as a board. So this quote here about, what causes issues is the quote, arbitrary use of power. So this is where that sort of sample best language comes into play, because it's creating a known quantity procedure for unit owners to follow. There's clear expectations of what kind of materials that the board wants to be looking at and what information has to be provided. So we tell people a lot of times that you do want to maintain a certain level of transparency, so that unit to unit, it's clear that consistent standards are being applied, and so that everybody knows what the expectations are. So we recommend issuing written decisions, so that you can put that in as part of the records of the association, and so that there's a clear statement of what all the terms are going to be of what's being allowed. One of the things that we have run into many times is sometimes there is an existing modification that has been made to a unit, and the unit owner says, oh, well, I got approval for this modification from the prior board, but nobody can find anything in the association's actual records. Sometimes it's because no approval was actually given, and sometimes we hear from prior board members who say, oh yeah, we did approve that, but we never actually had any kind of document or agreement to say anything about it. And well, that doesn't really doesn't really help anybody. So as I talked about, you want to make sure that you're treating all owners consistently in terms of similar types of modifications. So you don't want to run the risk of certain owners saying that they are being treated differently for whatever X reason, which could be as simple as these board members just don't like me. So they approved everybody else's modifications, but they denied mine just because we're not friends. So part of that, all your decisions need to be consistent with terms of governing authority. Okay, so that's based on what your condo docs say. There's certain procedures that are required by law, potentially in addition to what is stated in your condominium documents. So part of the process that we mentioned is ideally requiring that specifications and plans and contractor information and permits all be provided as part of the application process. So, to cover your bases and show that your decision was well rationalized and well informed, you want to note in your decisions that you looked at all of those things, especially if you're deciding to deny somebody's application. Then you're able to point specifically to whatever it is in that documentation that was the basis for why you're denying the request. That even could be something as simple as if you're talking about architectural design integrity, that the colors and materials that were being proposed weren't consistent with the character of the rest of the property. But you need to be able to have something to point to in case somebody challenges the validity of your denial.
Just real quick before you move on, Justin, on the rationale being provided for the decision, I recommend that boards note any specific circumstances relative to a particular proposal, especially of the unit itself, if that's factoring into the decision. In other words, I've dealt with boards that are approving something, and I was kind of surprised actually that they were approving it. And then they said, well, this unit is at the end of the row and it's the last row, and the only thing outside their unit is the woods. So this is going to bother nobody. It's going to be seen by nobody. Well, okay, that's fine. I would then make sure that I say that in the decision. This way, when another owner asks to do the same thing, and you want to say no because it's going to be in the way, it's going to encroach on other units, it's in the middle of the place, it's going to bother the neighbors, whatever the case may be. If your original decision noted that the particular circumstances here are such that there's no issue with the neighbors, that could be important, because next time around, the board might be tempted to say no if the circumstances are different. And if you stated in your decision exactly what you're doing and why, it's going to make it harder for someone to do that thing that you mentioned, which people love to do, and say, oh, they denied me because they don't like me. So the rationale can be pretty important, and it should include, any of the factors that the board is finding important in this particular instance.
So like Gary mentioned a little bit earlier, certain of the modifications can require an easement or limited common area agreement. That's typically going to be modifications that are something that's a little more substantial. That'll be something like installing or extending a deck or a patio, or putting in a air conditioning condenser where none may have existed previously, or a generator installation. And the reason for that is, in certain cases, some documents may say something like, each unit has a limited common area. If it has a deck, that deck is limited common area. But we'll usually say something along the lines of, as indicated on the site and floor plans. So if somebody is asking to put in a deck, what you're going to be creating by allowing them to do that is a new limited common area. So in Massachusetts, under Section 5B2 of the Condo Act, the creation of a new limited common area has to be memorialized in a written document that is recorded in the chain of title of the unit. So it's important to pay attention to when those types of agreements are necessary. And one of the things that we try and address in those agreements as well is not just, the creation of the limited common area, but also the terms of responsibilities. So, you try and talk about, well, what happens if the limited common area element has to be removed for the association to do work on common area. So for instance, if a unit has a roof deck and the association needs to do work on, the roof membrane underneath, the agreement can specify that the unit owner is responsible for the costs of removing and reinstalling that roof deck so that the association can perform maintenance and repair work on the common area roof that's underneath. And another thing to note relative to these easement agreements is they may require the consent from owners of immediately adjoining units. So there's no definition of what an immediately adjoining unit is in the statute, and there's no binding case law on what that is either. But there is some case law that we can use for its persuasive value, which basically says that it's any unit that is substantially impacted by the use of this new limited common area. So factors that they'll look at there is noise, vibrations, visual impacts, something like that. It's a little bit of a mushy standard, but it at least gives us something to look at. Some modifications that are a little bit more minor, those can be accomplished and memorialized through the issuance of a license agreement. Again, the major purpose is to create the clear expectations of the unit owner's rights and obligations relative to that modification. This could be things like doorbell cameras, or in some instances like awnings that people put on. And the major difference with a license is that they are revocable. So the association can rescind its permission for that modification at any point.
Justin, just real quick, that provision is cited of the Massachusetts condominium statute relative to the granting of the easements and or creating limited common area, things of that nature. Just occurred to me for folks in New Hampshire. I don't know how many states are represented in the viewing audience today, but for folks in New Hampshire, if you're wondering, the statute says that whether or not future limited common areas can be created or designated must be stated in the documents. And so once again, it comes back to what do the documents say, because that sort of dictates what the board can or can't do. And short of the board having the ability to do that, you might be looking at, a 100% vote of the association if you really wanted to change the designation of an area to allow some type of project. The only other thing I want to say is we do have a couple questions coming in. I will be mindful of those. We are going to do Q&A at the end. So before this session ends, everybody should have answers to their questions.
So in terms of the documentation on these written decisions, you want to have them signed consistent with the standards for board decisions that your governing documents state. So, if your general standard is a majority of the board, then you want that to be the number of board members who sign the decision. The reason for that is just so that the document on its face is a valid action of the board. In a lot of cases, we've seen something where the decision document may just have been signed by the board president. There's, depending on the circumstances, there may not be a requirement that it be signed by a majority of the board, but it opens the door for questions down the line of whether that decision was actually made by the requisite proportion of the board members. That's your minimum standard, is whatever the threshold level is for typical board decisions. As we note here in the tip, signatures of all board members is the best practice. Then you kind of have an ironclad unanimous support. So it's important, especially when it comes to the documents that are going to be getting recorded, these easement and these limited common area agreements, that when the board members execute these documents, that you both sign and print your names clearly and date your signatures.
All right, this is going to be the final third of the project in terms of the subtopics. And this is, how can the board enforce against unauthorized exterior modifications? So now we get to that, what I'll call nightmare. Usually it's a nightmare, the ones I've heard of, that nightmare situation where a unit owner has already gone ahead and done something that they ought not to have done. They did not have the proper approval and so on. How does the board deal with that? This question does come up quite a bit. So first off, there is what I refer to as the in-house process in terms of the path of escalation. In other words, on day one, I think everybody, the thought crosses their mind, oh, this is maybe going to be a legal issue. And that's fine. But there does need to be, some background and some foundation for a case, especially if it's going to be a legal case. You need the steps, the appropriate steps to have been taken at the outset, and for the case to have a good record for you to provide to legal counsel that they can act on. So step one is going to be either an observation or a complaint. And what I mean by that is that, if the board's doing a walk around, or maybe a board member just notices when they go to get their mail, or because of something they passed while they're driving in or out, board member may directly see something. Observation. Complaint obviously would be from another unit owner. Most folks know that there's no shortage of complaints around, or willingness of people to complain about their neighbors. So usually there's no problem hearing about something that someone's doing wrong. Once that happens, either the observation or a complaint being received, the board should conduct some form of investigation. In other words, even when we think we see what's going on, and because of what we see, we think we know what's going on, we should still engage the unit owner in some fashion. We should still sort of look into what's happening. There have been those boards that fortunately, before they went 0 to 60, they reached out and found out that the reason why someone's having a railing installed is because someone just got confined to a wheelchair or a cane or a walker. There are circumstances where as a board, you're going to want to treat a situation somewhat differently, than to just go 0 to 60 that someone's engaging in misconduct. So it's always a good idea to collect some information and get a better sense of what's going on. So after the board does an investigation, the board's going to come to some conclusion about the matter, make some decision about the matter, and that is going to then issue to the unit owner. And I put decision/demand because if the board has decided that what has happened is in fact a violation, is unauthorized, cannot be condoned or permitted after the fact, something just needs to change, it needs to be fixed, then that's going to start by way of demand to the owner, where the board says, this is what is wrong. This is what we're not willing to live with, and this is what you need to do to fix the situation. It doesn't always have to be the case that someone goes 100% into backpedaling. Even if they failed to get the prior approval that they needed, it is ultimately best, because this is what judges will do if it gets to the courtroom and the judge is looking at the situation. It is ultimately best for the board to sort of look at the whole thing with a fairly open mind, and a rationale towards, well, what do the docs really say, what's really at issue, and can this unit owner comply with what they need to or not. In other words, sometimes it's not a matter of saying you're not going to have a deck. Sometimes it's a matter of saying you did 12 feet, we only do 10 feet in this community, that the 2 feet needs to come off, something like that. But generally speaking, the strongest case, if a board is going to pursue enforcement, the strongest case is one in which your demand to the owner isn't necessarily the most comprehensive demand you can possibly make in the situation, but rather, what do they need to do in order to bring themselves in line with what would be acceptable at the community.
And in some instances, if you're able to, catch it early, before the process has really gotten super involved or even completed, part of what you can do is tell them that they just need to stop whatever it is that they're doing and begin the application process.
Right.
And you may be able to just give an approval for whatever it is that they actually had planned.
Right. If things happen in a timely fashion, instead of needing to remove the last 2 feet from a deck that's done, maybe the unit owner finds out that 10 feet is as far as we can go. So we're going to change our plan, and it's going to get built as 10 feet in the first place. That's why it is important for boards to act on things in a timely fashion. It is important for boards to sort of try to keep an eye on things and know what's going on, because even just a couple of days in a given case can change the situation drastically. Last part of the in-house process is sort of where the in-house process ends, which is to say that if the situation is unresolved, meaning that a board has communicated to the unit owner what they're doing wrong, what needs to be done to remedy the situation, when you have to remedy the situation by, and if that deadline goes by, the unit owner hasn't done what they're supposed to do, then it is time to refer the matter to legal counsel so that things can proceed in terms of addressing the situation.
All right, so the observation and complaint stage of this, as Gary already alluded to, there's usually no shortage of complaints available from neighbors. People are usually pretty quick to say, my neighbor's putting in a deck and I don't like it. But generally what will happen with the complaints is that you're kind of catching it at a late stage. Say for instance, somebody put in a mini split system and they have the lines running along the exterior of the unit and they put the condenser in. You may not hear about it until the neighbor is complaining about the noise that they're hearing from the condenser whenever it runs. And at that point, all of the work is done. All of the penetrations have been put into the walls already, and work has been done on the ground to put in this condenser. So for that reason, and what I was talking about in terms of potentially catching things early, it's really important for boards and managers to try and do periodic walkthroughs of the property. That way, you're more likely to see some kind of work going on at a unit and go, okay, what's going on over there? Do we have any kind of record of some kind of request for this work to be done? Instead of finding things after the fact. And, another problem with finding out about these things when you're not doing your regular walkthroughs is maybe you find out about it very late. And, you then reach out to the unit owner and tell them, hey, this deck expansion was unapproved and you need to remove it. And the unit owner goes, well, it's been there for 3 months and nobody said anything to me. That can make the situation a lot stickier and make unit owners a lot more resistant. And another factor there with the timing is that when it comes time, if necessary, to go to court, one of the things that judges can consider is, the equitable aspects of this. So what would it cost for the unit owner to restore the area to its previous condition compared with whatever harm the association and the neighboring owners would experience?
By way of clarification, I'll just say so everyone's aware, because the question comes up a lot. Does it mean the association has lost if a unit owner manages to quickly do whatever it is that they're doing that they shouldn't be doing? No, it doesn't mean you've lost. It doesn't mean that you can't take up enforcement. It's just that when the thing, whatever it is already there and the work is already done, it's just a tougher case. Doesn't mean you can't do it, doesn't mean you might not win, but it's certainly harder. And a lot of times the outcomes, because judges, they have the power, but they don't really like to be the bad guy. And so a lot of times those are the decisions that come out as more of a compromise, where, a unit owner is like required to correct something to a certain extent, but not completely remove it. Judges refer to it as waste, the idea of something that was built being torn apart, and they're reluctant to get into that. They will under the right circumstances, but again, it's just a tougher case. So the in-house process, the investigation, I mentioned this a couple of minutes ago. It should include communication with the owner and a search for any prior approval that may have been provided. If it was done appropriately, some documentation of a prior approval should be in the association's records. It's always good to look for that, because if you can find it, you might either avoid a problem or even an embarrassing situation. There are those boards that go 0 to 60 when it comes to enforcement, and they accuse someone of wrongdoing and they threaten them with this, that, or the other. And then if that person happens to pull something out and they can show that what they're doing was approved, even if it was by a prior board, then that can be problematic for the existing board. And if you've already alerted legal counsel and gotten them involved, you may have started incurring expenses. And, the job of the board is to protect the association. Part of that is making sure that even when you do have to take action against a unit owner, that you're doing it in a careful way, and that you're A, likely to succeed, and B, recover as much of the expense as possible.
So from there, once you've completed your investigation process, then it comes into making your decision on how you're going to address the issue. There's not a lot more to say about this beyond what we've already mentioned, which is that you should make sure that you're documenting the decision and the rationales with a written document, and that you're making your decision consistent with past practices and based on the specific circumstances. So again, we've talked about, solutions that are short of just demanding complete removal, like I mentioned previously, it may be, hey, you need to stop. You're supposed to get approval, so you need to give us your application with all of this required documentation, and we'll take a look and see if what you're doing is okay. And then if it is, we'll let you go ahead.
Okay, so a couple things. I think this is the last of the substantive slides. I'm going to speak to this one fairly quickly. And then for those who have questions, know that it's a 12 to 1 o'clock program, but we are going to continue to be here. And so we will provide answers to the questions that have come in. We can take new ones. Justin and I do not have to run from this at 1 o'clock, so we can still deal with questions. The legal process. So now this is where the in-house process has not resolved the issue and the matter does get referred to legal counsel. There's essentially only two phases for us. One is a cease and desist notice. That's a real formal legal letter, usually several pages long, usually runs through the formal ownership of the unit, what the unit owner has done that's wrong. There's usually specific mention of the relevant provisions of the governing documents. So it's explained why what is wrong is wrong. It is explained to them what they have to do to remedy the situation, as well as what the consequences will be if they don't. If the cease and desist doesn't work, then step 2 is seeking relief from a court. And in these cases where unit owners are doing something that they're not supposed to be doing, specifically if they're changing things outside, then it's going to be a court complaint seeking an injunction requiring the unit owner to either stop doing something or to fix something that they've done that shouldn't have happened. And as a note here, there's a statutory provision in the Massachusetts Condominium Act, the 183A, Section 6A2, that says that unit owners may be assessed all expenses, including legal fees and costs, resulting from their misconduct. In New Hampshire, it's a little bit higher stakes game because what 356B says, and that's the New Hampshire Condominium Act, at section 15.2, it says that the prevailing party is entitled to recover legal fees and costs. So if you're the association and you're pursuing a violation by a unit owner and you win that case, then you can get your legal fees back. But it's a high stakes situation because if the court does not agree with you for whatever reason, then the unit owner has the potential to get their legal fees from the association. So with that, I think we're on to Q&A. We can alternate these, Justin, or you can jump in if you have a thought. The first question I see is on one of my slides, and the question is, can the best scenario, this is when we're looking at the different language in the docs, can the best scenario be done as part of the rules and regulations instead of amending the documents? So the limitation of rules and regulations is that they really pertain only to the common areas. And so depending on what you're trying to regulate, that's really going to determine whether you might be able to be in the rules or whether you really do need to amend the documents. If you are getting into the units or even outside area that a unit owner owns as part of the unit, then you're going to want these things to be in the documents as opposed to the rules, because the rules are only for the primary common areas of the association. Now, by way of example, because I wouldn't blame anybody if right now they're saying, well, what would be outside that the unit owner owns? Well, depending on the association and how the documents were written, sometimes unit owners own their front porch. Sometimes unit owners own their deck. There's any number of things that, as long as the documents say it, then it's so. And if the documents say that the decks and or the porches are part of the unit, then they are. And so if you want to be able to govern things like that, then you're going to want to be within the documents themselves as opposed to the rules and regs.
Next question we have here is, what if the board approved the exterior modifications such as EV charging stations, but the owners are not aware of that upgrade? Are owners allowed to not pay supplemental fee if required because of the modification? I'm not sure I fully understand the question, but it sounds like what we're talking about is a modification made by the board as opposed to a request from a unit owner for the unit owner to make their own modification. So it's sort of a different area here because additions and modifications by the association are subject to the improvement approval requirements of the documents and the Condominium Act. So as long as you have an improvement, such as the installation of electric vehicle charging stations that are made by the association as an association expense, and you follow the improvement requirements imposed by the statute, then the costs for that project are going to be a valid common expense. And, the unit owners will have received notice of this proposed improvement and the opportunity to vote on whether to approve it or not. And as long as that happens, then they are going to be required to pay the supplemental fee, whether or not they, quote unquote, had actual knowledge that it was going to be happening.
So next question provides background fact that the roof is common area and that the attic is referred to as the space above the living area. Also, no one is supposed to use this space, the attic space, except for servicing HVAC equipment. And then the question is, can an owner put additional insulation or remove insulation from that area? So the first part of answering that question is going to be pinning down, sort of the characterization of that area. In other words, is the attic part of the unit or is it common area? If it's common area, then it's under the control of the board. And the only way the unit owner is going to be able to do anything there is with approval from the association. If it's part of the unit, then technically the unit owner is going to be able to do something on the inside, subject to any provisions of the governing documents that talk about unit owner modifications. And sometimes even when the modifications are on the inside, which is not, this seminar's topic, but sometimes even when unit owners are making modifications on the inside, the documents will require them to get board approval. And usually to do that, they have to demonstrate that the contractor is legit, that they have a license, that they have insurance, that they have a permit if they need one, and so on. And so how that situation turns is really going to depend on what that attic space really is. In terms of getting to that answer, the condominium documents of every association will have in some way, shape, or form a section that identifies the boundaries of the units, horizontal, vertical, and so on. Usually what they say in terms of the basement to the roof line is that the unit ends a lot of times at the unfinished surface of the uppermost ceiling, or you might read that the unit ends at the innermost surface of the joists in the ceiling, something to that effect. If that's where the unit ends, then the attic is going to be above that, which means the attic is outside of the unit. If, however, the unit is deemed to end at the roofing boards below the shingles, or the plane of the joists of the roof, Now the boundary of the unit has gone all the way up such that the attic is going to be part of the unit. But that's where you're going to want to look in the documents, and based on the strict boundaries of the unit, then you can define the attic space, and then you can sort of finish treating it appropriately depending on whether that attic space is unit or common area.
So the next question is asking, so in the situation where the condominium documents are silent about what records are required for board decisions, is there in Massachusetts any other legal requirement? There really isn't strictly. The Massachusetts Condominium Act does not even strictly require meeting minutes to be kept. The only real reference to it is that meeting minutes, if any, have to be kept and made available to unit owners to access. Yeah, do you have anything to add on that, Gary?
No, I think that about sums it up. What we call best practices is the term applied to things that you don't necessarily have to do under the law, but that are the best way to operate. If you're thinking about either efficiency or avoiding problems, or just trying to keep things straight. Next question says that there is a unit owner that repeatedly requests to install a mini split system in a garden style unit that's on the 3rd floor where only window air conditioners are allowed. The issue is revisited often, has been for over a decade. It has been denied this request by multiple boards. Any suggestions in the wording to be used to try to put this issue to bed permanently? That's a tough one, because generally speaking, unit owners are entitled to make a request and get an answer from the board. And on the one hand, the present board, if they want to be done with the issue, could say in a decision that this is being denied, that it has been denied in the past. If they want to get into details, they can say this has been denied 4 times on the following dates. And they might say the unit owner shall not submit this request again, as the board will not consider this request again in the future. Now, you can say that. Sometimes judges even say it. There are those unit owners that have sued their associations multiple times. There are litigious people out there, and if their claims don't have merit and the judge sees a pattern and they want to put a stop to the pattern, they will sometimes issue a decision that says this unit owner cannot bring another claim against their association. The problem with doing that as the board, in saying don't make this request again because we're not going to look at it again, is that the board is not always going to be the same. And in the future, if there are different people sitting on the board, they may choose to look at the request again for whatever reason, or maybe something changes somewhere along the line for the association. Who knows what that could be. Window air conditioners are allowed. It might get discovered that the window air conditioners are damaging the building because rain and whatever is getting into the windows and leaking into the building, or rotting the window sills, or anything. Something could change over time. And so because of the possibility that the circumstances might be different, and because of the possibility that the members of the board might be different people, I'm not sure that anything's going to stop someone from asking a question again and a board from answering it again. But I think the only way you create that possibility is to say in a written decision that this has been denied in the past, it's being denied now. The unit owner is asked to not resubmit this request because the board isn't going to consider it again. And I guess that would, at a minimum, it would apply to whatever's left of the term for the existing board.
The next question we have here is what happens when your bylaws state that 75% must approve for exterior change, but the board didn't follow that. So that's if you're talking about an exterior change by a unit owner, that's a very unusual provision to have. Typically, the documents will just require some kind of permission from the board as opposed to input from the community. But if that's the case, then that board approval could potentially be challenged and be determined to have been invalid because they didn't follow the required procedures. I would think that in all likelihood, the 75% requirement is, again, in relation to the association common area improvements that I talked about previously. Those are the changes and additions that are made by the board for the association, and those will require that level of approval.
All right, next question says, what if facade alterations were done by a previous unit owner? It did not catch the attention of the trustees back then. Can the board require the current owner to restore the facade at his expense? Interesting question. I would say that this is that scenario that we talked about during the seminar when we said that some of these cases are just tough cases. It's possible to bring them, but it's going to be a tough case. This would be that. You know, on the one hand, the board can say, the docks are the docks. They were out there for anybody to see. The rules should always be followed. They are restrictions that run with the land and that we can always enforce. And so here we are, Your Honor, to enforce this provision. In fact, a lot of sets of governing documents have a non-waiver provision that literally says explicitly that if a violation isn't acted upon by the board or the association at any given time, it does not mean that the right to act on it is waived in the future. And so sometimes when the docs are written, someone was even thinking to make sure that, well, if there's ever a board that's not doing a great job for a while, we don't want the association to be permanently doomed, and a future board that wants to do the job needs to be able to do the job. So can you bring the case? You can. Is it going to be a tougher case? It is. And the reason is that depending how much time has gone by, the judge might have some amount of sympathy for this owner who says, look, it hasn't been a problem for the past 3 years, so it shouldn't be a problem now. Or, you know, might say, I've already spent all this money. Or like in this case, the alterations were done by a previous owner, and now someone else is there. That unit owner may say to the judge, oh, I didn't do this. I'm not the one who did it. And if they wanted to take issue with it, they should have taken issue with the guy who did it. But that's not me. And so all of those arguments are there, and it's really going to depend on sort of how the judge feels on that day about how strict an interpretation they want to give to everything. The association can say to someone, hey, buyer beware, do your due diligence. You should have looked, if you were buying a condo, you should have looked at the docs. The docs show your unit without a deck. So when you saw the deck there, you should have had a question. You can make that argument. It's a perfectly legitimate argument that it should have been part of the buyer's due diligence to realize that something was different and to ask about it. But again, it's all just going to be in the hands of the judge. And these are the types of cases that, you know, could go one way or the other, depending on how the judge feels.
And on the flip side of that non-waiver provision, there are sets of documents that actually state that unit owners can only be held responsible for such violations that occurred during their time of ownership. So that's another thing to look out for, and why it's so important to look at what your docs say.
Yeah, if that's in your docs, then the case is a non-starter because the new owner cannot be held accountable. Let's see, next one I see here says, actually, Justin, you're on the next one. You just added to mine.
Yeah, so this one says when a unit owner hires a contractor for an exterior modification, should the association also be named as an additional insured on the contractor's insurance? That I would say falls into a best practices category. Sometimes that can be problematic. It can be a major complication for the contractor, and their insurance may give issues, and then the unit owner may get upset. So best practices is to try and seek that out, but you don't necessarily have to go that far.
Yeah, I mean, I would say it's nice if you can get it, but the law doesn't require it. So, yeah, it's sort of something to ask for, and then, see what the response is. And depending on the circumstances, a little project is not going to warrant the same level of interest and potential back and forth about it than a larger project. But generally speaking, as long as the contractor has insurance at all, to the extent that they do something wrong, that insurance is going to come into play. Next question says, I want to use Zoom to resolve an issue on an in-house basis with the board. They want to use WhatsApp so that there won't be a recording of the meeting. Thoughts? Couple thoughts. One is that for any meeting of the board, one would need to check the association's documents and the applicable law, depending on the jurisdiction, to make sure that the board can have this meeting as an electronic meeting. In other words, it might be a non-starter if either the law or the docs or the combination of the two are not putting the board in a position to have an electronic meeting. I would first make sure that that's valid. When it comes to recording the meeting, I don't think it's as substantial an issue, because there is no requirement that meetings be recorded, short of meeting minutes. There isn't a requirement that a board meeting actually have an audio or video recording. It's just not required by the law. And in fact, in both Massachusetts and New Hampshire, we have what are known as dual consent states, meaning that both sides to a conversation would have to consent to that conversation being recorded. Otherwise, the recording is illegal. So generally speaking, in Mass or New Hampshire, unless both sides want to be recorded, the recording shouldn't be happening anyway.
We should note, though, that in New Hampshire, if you hold a board meeting that is not open for attendance to the unit owners, that the statute requires that meeting be recorded and the recording be available to the unit owners for a period of time.
Yeah, that's the price for keeping a meeting closed that would otherwise be open.
So the next question we have is, can a board assess fines for non-compliance? The general broad answer is yes. Usually you're going to be able to do that. The Massachusetts Condo Act specifically discusses fines, so you can point to that as the board's authority for levying fines if it's not discussed in the condominium documents. One of the things to pay attention to when it comes to fines is looking to see if your documents cap the fine amounts. There are some documents that do that. The ones that do, most of the time, they're very outdated, and you're probably looking at something like $10 or $25 per offense.
Okay. Next question. Patios put in without an easement agreement, should they be obtained in retro? There's a couple questions here. That's the first one. I do think it's best for there to be an agreement so that the terms are clear to both the association and the unit owner. And in the event of an issue, it can be enforced. That said, if the agreement wasn't used in the past and the patio is already there, there isn't a legal sort of leveraging mechanism that will force someone to sign an agreement after the fact. And so I do think it's worth, a board giving it a try when those circumstances exist. But if the unit owner is refusing, there really isn't something to leverage in terms of a legal requirement. The exception might be if the easement, if the patio that was put in without an easement, if that was done improperly, meaning they didn't even have permission for the patio. Well, now the association has some leverage because now the proposition to the unit owner might be, we'll let you keep the patio if you sign the agreement. Otherwise, since the patio shouldn't be there at all, we're going to make you take it out. At that point, you might have some leverage if the patio is not supposed to be there at all. Second part.
Well, so Gary, one of the things that I offer as a sort of selling point for trying to get unit owners to sign the agreements if there isn't an existing one is that, under the Mass Condo Act, if it's creating a limited common area, then the Condo Act requires that be memorialized with a recorded document. So getting the agreement with the board actually can potentially help the unit owner as well, because they never have an issue down the line about whether or not this patio that they put in was put in properly and with approval, so that protects them and future buyers as well.
Yeah, so if you're in Massachusetts, that proposition of, you either sign the agreement or it has to go, that's supported by the statute, in that you can say, without the agreement, you are not in compliance with the law. So you have to have the agreement, or you're going to lose this item. Next question is, does an easement agreement apply to fences? The answer is it's going to depend. An easement agreement is where the owner of property allows someone the ability to do something or put something on their property. So for starters, the question is the fence going to be on the property of the fence owner? Because if so, they wouldn't need an easement to put a fence on their own property. Or is the fence going to be on someone else's property, like the association's property, in which case it would apply to fence. It would apply to anything that someone wants to put on the association's property. The board would have to allow it, and the board would have to provide an easement for it. Otherwise, there'd be no right for one person to put something on the property of another.
And I'll point out as well that some documents have language where, say, it includes a limited common area, yard area that extends from the unit. And sometimes they will include language allowing unit owners, sort of as a matter of right, to make certain kinds of modifications in those spaces, which a lot of times will include fences. So it's a question of whether camera doorbells and cameras need permission. Typically, yes, because a lot of documents will say that the design integrity of the property can't be modified without permission. So, if it says something about how you can't make exterior changes without board approval, that would include doorbell cameras.
Yeah, a lot of times at a condominium, it's the association that owns the siding that something's being screwed to, or the outside post, of a roof or porch is typically owned by an association. And so unit owner, even if it's at their unit, doesn't have really any authority, regardless of what the item is, to start screwing things into those pieces of property that are owned by the association. Next one says, after the unit owner has submitted their request for the work, interior or exterior, how long, how long should the condo association have to reply? And what should the unit owner do if the association does not reply in a timely manner? So that question is often answered, like so many, by language in the governing documents. In other words, a lot of times when the documents do speak to these issues in a thorough fashion, and they say that the board must be asked for prior written permission, and that the board has to, issue such in their discretion, and so on, it will say how long the association has. I've even read condominium documents that specifically say if the board doesn't provide the decision within the 30 days or the 60 days that they're being allowed. I've even seen it in the docs where it says if the board doesn't provide that decision, then the unit owner can assume that the answer is yes and proceed with their project. So as a first step, I would say take a look at the governing documents in question, because maybe there's a timeline there and the consequences might even be listed there as well if the board doesn't comply with the timeline. Otherwise, I think I would probably default to, good communication is extremely valuable. And so I think I would communicate with the board in writing, so that, the words are captured and the timing and all of that can be demonstrated. And I think I would say to the board, it's been X amount of time since I gave you my proposal. Wondering if I can have a decision on that. I'm waiting to do this project. If there's anything else you need from me, please let me know. Something along those lines, and create a record that way, so that you can show that you were reminding the board that they owed you this answer and that they had a reasonable opportunity to address the situation.
Next question here is, we used to require a building permit prior to board approval, and the city has now decided that no permit will issue without board approval. So in that case, it's not necessarily an issue, but you want to make sure that you're still covering your bases by making it clear to the unit owner that once they obtain that municipal permit, that they provide you a copy before they start any work.
Yeah, I've actually dealt with this before. It has come up, and the language that we have included for the association has been something to the effect of that the unit owner will either produce a copy of the permit before the physical work begins, even though the board's giving them an approval today. They have to provide a copy of the permit before the physical work begins, or a copy of a statement from the municipality that says that a permit is not required. And so if the board has to make a decision before the municipality does, that would be the way to do it. Just put some language right in the decision that says what the conditions are. Can the board require the owner to obtain insurance by a contractor for work inside the unit, with the reason the contractor is getting to the unit through the common area? I mean, that reason is fine. It makes sense, and practically speaking, it's true. But I think in general, boards can require contractors doing work even inside a unit to have insurance. The insurance isn't there just to protect that unit or that unit owner. They may be willing to roll the dice and take their chances, but in a condominium setting, if something is done improperly, even within one unit, it may actually pose a danger to other units. or it may damage other units or hold the potential to, as well as common areas of the building. And so generally speaking, an insurance requirement is sort of viewed as mandatory by almost all boards in all situations. And I think it's something that's really hard for a unit owner to try to argue that they shouldn't have to meet, because they're not operating in a vacuum. Even when they're in their unit, they can be affecting common areas or other units, or at a minimum, even if they're not directly impacting them, they're creating the possibility for that.
So the next question is, are boards required to open their monthly trustee meetings to owners? In Massachusetts, that's really going to depend on what your documents say. There's no default requirement imposed by the Condominium Act. New Hampshire, on the other hand, has a minimum frequency of quarterly open board meetings. And then, as I mentioned, if you're holding a board meeting that is not open to the unit owners, it has to be recorded and the recording made available.
Next question here. How does one enforce deck installation when board members are friends? So, few thoughts here. This is where written decisions are helpful, because if all else is the same and the units are similar and the decks that are being requested are similar, or a lot of times even the same, then the decision should be consistent, and the written decisions would show that from one person to another. If the question's being asked maybe because someone might be doing something wrong and they have a friend on the board, then I would add that when board members feel that they have any sort of personal conflict in a situation, they should be recusing themselves. And so if the friendship is that strong, that it's going to affect their ability as a board member to render an objective decision about the matter, then they really should be recusing themselves in that instance.
I'm actually going to skip over this next one. It's not really on the topic that we're talking about today. But this next one that I have is, what are your thoughts about refusing to consider a request from a unit owner who was delinquent in paying their condominium fees? That is an interesting one. I don't know that I've actually had that really come up. But there's nothing in the Condominium Act that would particularly address that. There's nothing that says that you can't still consider a request from a unit owner who's delinquent. Your docs probably are silent on that too, but it is something that you could build into your document language if you're amending it. A restriction that a unit owner has to be current on their assessments before the application will be considered.
Yeah, I would say that one definitely turns on condo doc language, because the law certainly does not say that a delinquent owner loses the right to make a request and have a request answered. And so that loss or that penalty, if you will, associated with being delinquent would have to be imposed by the association's documents directly. This next one says, I realize this is mostly exterior, but what I just found in the unit below me in renovations scared the bejesus out of me. We are an 18-story waterfront cement building. Then it continues. What I found was contractors jackhammering the concrete floor to install piping for a hot tub. No formal approval was given docks limit a unit to the concrete floor. So again, this is going to turn partly on the unit boundaries. That's what's going to define what the area is. Mostly the boundary of a unit is the upper surface of the concrete floor, which means that the unit owner doesn't actually own that concrete floor because the unit stops at the upper surface of it. So if the unit owner does not own that concrete floor, they absolutely should not be jackhammering it without approval from the association, regardless of the fact that that is inside the unit. And that is something that the association may want to take swift action on, because needless to say, the foundation of a building is one of the more important aspects of the building for all of the units in that building. And also, even if there's a way to do that right, and even if the board were inclined to allow that to happen, that's a situation where they're going to want to see a report of a qualified professional, such as an engineer, someone who can actually give a determination as to what you can do to that concrete floor and how you then fix it in order to preserve the structural integrity of the building. Because obviously, under no circumstances should anybody be allowed to put the structural integrity of the building at risk. So that one's going to need a professional opinion. Even if the board wanted to allow it, I would always tell a board that you're going to need to require the unit owner to do it in a way that doesn't harm the building, and to get that, qualified by someone who has the right credentials to assess the situation.
Next question is just whether the slides in the webinar will be made available. They will. I believe you will actually be sent a copy of the slides. And typically we make the recordings of these webinars available online through YouTube. You can access them from our website. Not sure how long that usually takes, but it will be available.
Yeah, and I think they got sent by email to the folks who registered. This looks like it's the last question. I'm not sure if I understand it. What if they are passing through the common area for a simple repair? The example given is to fix a running toilet. Follow up on requiring insurance for work in unit. So if the question is, can the board require that a contractor have insurance? I think that the answer is yes. And again, I don't think it's dependent upon the fact that they're, traveling through common areas or anything like that. I think it's the fact that work that's done in a condominium building, even if the work is done within a unit, may very well touch upon common areas, or it may, at a minimum, be adjacent to them. There's always the potential that if something goes wrong, it's going to immediately affect the common areas and or other units. And so for all of those reasons, I think that an insurance requirement is really considered mandatory by everybody. I've never heard anybody who's willing to be flexible on that.
And really the majority of documents have a provision that says that any work in a unit that involves the common area or threatens the integrity of the common area, that kind of work is prohibited except with approval from the board. So that's, in those instances, that's a condition that you can impose for granting that approval.
And some docs say that the insurance is a requirement as well.
Right.
And so that might sort of put the question to bed right there, if the docs say it. And if the docs don't say it, and a community decides that they want the docs to say it, then you just go through the amendment process to do that. And that's one, getting back to an earlier discussion in terms of the sales pitch, that's given to a community regarding a proposed amendment. that's one that's sort of easy to sell. Because you just say to everybody, imagine that the people upstairs from you are doing plumbing work and a cascade of water floods your unit when something goes wrong. Do you want to make sure that they have insurance or not? I think anybody could readily see the value of that language being there. So I don't think that amendment would be a tough sell. With that, we have now addressed all of the questions that have come in. It's 1:42 p.m. So we've gone past one, but answered the questions. Seeing none further coming in, I think at this point, I'm just going to thank everyone again for taking the time to join us today. Remind everyone that the recordings will be available, and that slides and so on will be emailed and available as well if anybody wants to review this in the future.
All right. Thank you, everybody, and enjoy the rest of your day.